भारत के पूर्व मुख्य न्यायाधीश यूयू ललित ने टाइम्स नेटवर्क के हरीश से खास बातचीत की। न्यायमूर्ति ललित ने कई मुद्दों पर खुलकर अपनी राय रखी। दिल्ली के छावला सामूहिक बलात्कार मामले में सुप्रीम कोर्ट के फैसले का बचाव करते हुए यूयू ललित ने कहा कि आरोपियों के खिलाफ पर्याप्त सबूत नहीं थे। उन्होंने ये भी कहा कि नए न्यायाधीशों की नियुक्ति के लिए कॉलेजियम प्रणाली सबसे अच्छी प्रणाली है।
We are joined by retired Chief Justice UU Lalit. Justice Lalit, you have achieved a lot during your limited tenure. What has been your biggest achievement?
I told the earlier interviewer that to my mind, Supreme Court's basic function is to lay down law and lay down law with authority, certainty. And the best possible way would be to have larger benches, combinations of 5 judges deciding matters, laying down law for the entire society, for the entire country. So therefore, as many matters as the constitution benches can decide, it will be good for the country. So therefore, when I took over, even 2 days before that, we published a list of 25 matters to be listed before the constitution benches. And to have 6 benches in this short tenure of 74 days, and to have those matters listed before those constitution benches, if you ask me, that's the best achievement that I could actually see to it with the entire help from the entire fraternity of my brother and sister judges.
So the collegium system has come under a lot of attack from the Law Minister Kiran Rijiju. He is calling it opaque and says it has to be revisited. Your view?
According to me, it's the best system. My view is that it is the best system. As I gave the answer to the earlier interviewer, it is a system where all the inputs are considered at the appropriate stages. Every consultative organ, whether it is the government at the state government level, whether it is the central government, whether it is the consultee judges, whether it is the High Court Collegium, whether it is the Supreme Court Collegium, and finally the government. So therefore all 6 bodies have a say. They are essentially the persons or the bodies who give sufficient inputs in the matter. It is as a result of those inputs that in the earlier collegium we could have 250 recommendations which were then fructified and were successful, and as against 750, which is the total all India strength of High Court judges, 250 were recommended by that very collegium in a span of 15 months. So therefore that you can very well, that's figures speak for themselves. So the collegium system is something which has actually proved to be successful.
So the acquittal of 3 death row convicts in the Chhawla Gangrape case has raised a lot of hue and cry. They say that circumstantial evidence was enough to uphold the conviction and endorse the death sentence. Your view, sir?
Who says that the circumstantial evidence was enough? See, that is exactly why we at the Supreme Appellate level, if we found that the circumstances were not well established, number 2, that the circumstances did not form a complete chain and which did not eliminate every other hypothesis except the guilt of the man, it is on these parameters that we saw the facts. After being convinced that the facts or the circumstances do not establish the guilt of the persons concerned, it is after that that we acquitted those persons. Now it is true that there may be a crime committed in the society. There are people who are accused of having committed that crime, but whether the guilt has been brought home or not, whether the authorship of the crime is proved or not, is a matter to be considered by the judicial organ of the society. By the very nature of the principles that we have adopted, trial court may say one thing, High Court may confirm something, but finally it is the Supreme Court which has to rule on that issue. And in that process, we did not find material good enough to sustain their conviction.
There is also criticism that the father was not personally allowed to argue the matter when 2 days before the judgment was reserved. Only father or the victim?
The lady was appearing.
Her father?
No, he was appearing. See, he was being represented by a complainant. We heard that complainant, and if I mistake not, I don't recollect the name of that lady, but she did her submissions. So therefore, it is not as if that the father was not allowed to make submissions. He was
Are
definitely
you disappointed that you could not make any appointments to the apex court?
not at all, not at all, not disappointed at all.